Music Publishing, Part 2, Section 2. We're going to talk about work for hire now. What is the technical definition? If it is made by an employee within the scope of employment, it's a work for hire. If the employer is directing or supervising the creation of the work. This was very common in the old days, Walt Disney Studios. They would have composers on staff. They'd come to work, bring their lunch, and they might write, Mary Poppins while at work, take their lunch box home, and that was it. And it was owned by the Walt Disney Company. Criteria for work for hire. It's commissioned. It's created under a written agreement. It's created for use in one of the following: a motion picture or other audiovisual work, a collective work, a compilation, a translation of a foreign work, or a supplementary work. These are the criteria for it being considered a work for hire. Let's talk about duration of copyrights. Anything published on or after January 1st, 1978, the copyright lasts for the life of the composer plus 70 years. For joint works, it lasts 70 years after the death of the last surviving composer. It used to be 50 years before that. And before the 50 years, it was 28 years with the ability to renew for another 28 years or 56 years total, if you did submit the renewal in a timely manner. You had to apply for the renewal, otherwise it would fall out of copyright after 28 years. What does publication mean? It means distributed to the public. Now, we've talked about this before, but right of termination is something that exists in US copyright law, not in other countries' copyright laws. This was added in the 1976 Copyright Act. You can get your copyright back 35 years after you transfer the right to a publisher. Does this apply to the world? I think I answered that already. No, USA only. Does it apply to work for hire pieces? No, because there was never a transfer in the first place. The employer owned the copyright from the very beginning. But you do need to give notice 2 years in advance. Now, digital performance of masters and webcasting. When was this first covered by copyright law? This was first covered in the Digital Performance Right in Sound Recordings Act of 1995, the DPRA. There's a compulsory mechanical license which extended to include digital distribution of records. It created a new right for the record company and artists to be paid when records are performed. And this is digital over-the-air broadcasts are excluded from this. Sound exchange. Digital performance royalties are paid to Sound Exchange, and you can check them out at soundexchange.com. Out of those payments, the record company gets 50%. This is assuming the record company owns the master recordings. Whoever owns the masters gets that 50%. The featured artist gets 45%, and other artists get the remaining 5%, which is paid to the American Federation of Musicians, the AFM, or AFTRA funds. Sound Exchange has distributed over $7 billion so far, and this is as of this year, 2020. There's no compulsory license for digital streaming. That was before the Music Modernization Act. When the Music Modernization came out, then there was a compulsory license for that, but there's some conditions related to that. The 1998 Sonny Bono Copyright Term Extension Act. How long did it extend the existing copyright term? 20 years. It's now 70 years after the death of the composer, because before the 1998 Sonny Bono Copyright Term Extension Act, it was 50 years. What about works published before January 1st, 1978? The term extended for 95 years from publication. Now the USA is in line with the European Union. There are some exclusions on the need to pay to secure a license and pay performance income in any kind of establishments. This came about in 1998 with the Fairness in Music Licensing Act. So, do all stores, restaurants, and bars of any size need a license to perform music? And the answer is no. This act states that stores under 2,000 square feet or restaurants and bars under 3,750 square feet don't need a license to perform music. This was advocated and pushed forward by the National Restaurant Association, the National Licensed Beverage Association. They lobbied heavily for this bill. The World Trade Organization, the WTO, was not happy about that. Copyright registration is how you get a copyright by sending someone something to the Copyright Office? No, it is by fixing the work in tangible form. Does registering the copyright give you certain legal remedies? Yes. Does failure to register affect the validity of your copyright? No. The negatives of not registering: you can't collect compulsory license royalties, you can't file an infringement action. If you don't register within 5 years after the first publication of the work, you lose the legal presumption that everything in the registration is valid. And you can't recover attorney fees, nor can you get statutory damages unless you registered before the infringement happened. So the legal remedies for copyright infringement: you get the fair market value of the use the infringer made. You can recover the infringer's profits. You can get an injunction. You can recover statutory damages if registered, and the court can order destruction or seizure. If the infringement is willful, there are criminal penalties as well. And you can get your court costs if the copyright is registered. That's the end of Music Publishing Part 2, Section 2.